welcome. Today is Judge John Stevens' courtroom. So let's get started with Judge Stevens.
Aaron Simpson.
Your Honor, I believe Mr. Rennick and I have worked out.
What are you going to do?
We worked out a deal.
What do you want me to do?
I'd like you to approve that deal when Mr. Rennick gets it.
Okay. It's not a dismissal. It's a plea.
It's an actual plea.
Okay. Where is Aaron Simpson? Is he in custody or out of?
He is in custody.
He is? Okay. Let's see. Well, let's wait until Rennick gets here. Mr. Rennick gets here. Okay. So I'm putting TBP. To be pleaded. Pled. Cameron Hernandez. Cameron Hernandez is called. No answer in the courtroom. That's in custody.
They're all in custody.
Everybody's in custody here?
Except for.
Not everybody, but
What's your final answers on that?
it's the vast majority.
Yes.
We do have a couple of people that are not in custody. On page 3,
Looks like John has Terry Jackson. He's got the multiple cases. This Jackson's got 5. And then he has Cameron Hernandez with 3. He's got Aria Lacaze or Lacaze, Gwendolyn Lanes, Vernon Williams, Denise Woods, 3 Denise Woods, Aaron Wiggins, Marcus.
Mr. Wilkerson texted this morning and said he's going to be about an hour late.
Well,
Text John and said,
hopefully we won't be here. Okay, yeah, text John, tell him we're waiting on him.
Judge, on Woods, state's prepared to go forward with the hearing on the MTRP. I have witnesses here, at least 3 witnesses, and 1 is en route.
Okay, that's good. I'll be here. And on Cameron Hernandez, what's our plan on that? Is that was Kyle Gasper? She's probably not going to be here.
Probably not.
No, sir. We're still busy reassigning those, so I don't think
It's set for a hearing.
Try to work it out whenever John gets here.
Is he on his way or?
that he'll be here in 30 seconds. So start the clock.
I don't want to count.
29, 28.
It's embarrassing when I take off my shoes.
You still miscount. Have you thought about numbering your toes?
Thought about it, but just the tattoos keep washing off.
And everybody's in custody?
Except for
2 people.
Lonnie's and Williams.
They're
Who?
on page 3.
Those 3, Lonnie's and
Look what I've done.
Williams.
Look, it was 30 seconds, I was in the elevator.
It was more like 32.
Gwendolyn Lannis, I'm sorry, they were talking.
That's Gwendolyn Lonnie's and Vernon Williams. Those are the 2 ones that are.
And Vernon Williams.
Yeah, they're on bottom.
Gwendolyn Lannis, where are you? Gwendolyn Giannis,
Your Honor.
Gwendolyn Lynn Giannis. No answer. I asked the bailiff to call into the hall. For when you can't make this stuff up. Gwendolyn Lannis.
This is the lady that was supposed to be here Tuesday who could not had car issues. Or Wednesday, whatever day we were here. I don't remember what day it was. And
I think it was Wednesday.
Wednesday, you said to get proof. I tried to get proof from her and she didn't. And talked to Lacey yesterday.
All right.
Said she put her today. And I'd like to read what she sent me so that way the court, at least it's on the record. It says, I'm trying hard to find a ride, but I'm not having any luck. I don't have money for a Lyft or Uber. I don't have much family, and what family I do have and can't do, and I don't associate with friends, so I don't ask for a ride because I don't have any friends. I work for a resale shop here in Baytown. I only make $250 every 2 weeks. Not even that I can get a boss to write a letter to show what I make and how I work it as part-time. My boss is a judge for Baytown, but owns a resale shop. She knows how much I make. What I'm trying to say, I don't have money for a Lyft or Uber. I don't have money to even fix my car. And I don't have a way out there. I can't even find a ride. I can't afford to go back to jail because I can't pay another bond. If the judge can look clearly into my record, he will see I have never been in trouble and don't ever want to be in trouble. That's not who I am. Please see if there's something else you can do for me, please. Thank you. So,
Okay, so what's your point, though? Everybody has the obligation to be here. And what she said is on her own terms, she's not going to show up and she doesn't want any sanctions to be made because of that. And we'll never see it. That's the way she states that. And that's not the way it can work.
I'm just
All right.
letting you know what she told me, Your Honor.
The defendant has failed to appear a warrant. I'm going to treat her like everybody else. A warrant shall be issued for her arrest because she's, what her statement is, she doesn't have a way to get here, so she's not going to be here. So we got to work without it, and which can't be done. So she has to be present, and it's difficult, more difficult for some than others. I can appreciate that, but I open that door, and it's I want the Gwendolyn Lannis rule. I can't be here either, just like her, and so put me on the side and you'll never see me and we'll never dispose of this case. And thank you. And that's the way it cannot work. So a warrant shall be issued for her. What is her bond?
Wanted after.
What is,
I think it was,
I ain't doing it,
it
but,
was 8,000 on Wednesday.
but there isn't another option. Unless you can figure out how we can dispose of it, or try to dispose of it without her presence, which is unauthorized possession of catalytic converters, huh? That's what she's charged with?
Sure, yeah, she was in possession of them. She didn't steal them.
What ladies do that?
That's part of the case. We think that it was somebody else's car. It was her boyfriend's car she was driving. They were in the trunk. I don't think she knew they were in there.
Okay, well,
But there was,
God bless it, grand jury thinks otherwise.
I know.
Okay,
Well,
her bond is revoked, a warrant issued for her arrest. Bond in the amount of $10,000 is ordered, and see, it's the memo says she's to plead. How does she figure to do that? I mean, that was her statement, or somebody on her behalf.
That was what we had an agreement that we were going to hear of it today.
Well, I mean, I'm anxious to do the agreement, but I hate to put her in custody. But you got to let her know there's a warrant for her, and the best thing for her to do is come in, surrender, plea, and I can get her in and out of that jail.
Yeah.
Okay,
Yeah, probation.
thanks. Yeah, we try to work with them, but we can't work with them when they don't show up by court order. That's a contempt issue too. Who else is not here, John?
No, that was.
So was there somebody else?
Vernon Wood.
Is Vernon Williams here? You're Mr. Williams? Okay. Denise Woods?
In custody.
Custody. Terry Jackson?
Custody.
Everybody else is in custody.
Ariel LaConte. I thought there was two.
Gwendolyn and
Yeah, Ms. Yanes and Mr. Williams.
Vernon? You're talking about Vernon Williams?
Yes, sir. You want to approach?
No, I thought you said there were two people who weren't present. Which was the other?
Not in jail, but.
All right,
Mr. Williams.
we'll deal with it. Vernon, come on up.
Oh. That's all I know. That's it.
There's one case here called. It is 25 CR 1839 Vernon Bronson Williams III. You're here with John West, your attorney, and the state's attorney. You're charged with unlawful possession of a firearm by a felon. Is this habitual felon status?
Don't know, Judge, and don't have the case. For some reason it wasn't
Was
on my docket.
convicted 2012.
Getting to it.
Convicted in 2013. This use of firearm in a crime of violence, then illegal possession of heroin,
Excuse me.
and then
That was loud.
after those convictions were final, he was finally convicted in 2018, introducing contraband into the correctional institution. Also in 2018, he was convicted of a separate offense of introducing contraband. So what we have here, though, is an habitual felon.
Yes, sir.
status. And where are we?
At this point, we were still working on it. I thought we had it set for down the road, and then it popped up on the docket today, so I'm not sure.
Oh, I'm sure we don't do something today, we go to trial, period, in a ball game, and which is 25 minimum to life. But I mean, you can't wait around for you to decide. You were indicted 7-8 months ago. You've had more than enough time to decide, but you're not eligible for probation
The jury, yes.
by a jury. This is what this is, sir. This was a decision on, let's say.
Yeah.
On what direction you're going to change.
Oh, it'll be divided up between one of the three of us,
You know,
4 of us.
which one is that?
I don't know. This
When were we here last?
I don't remember the exact date, but.
These cases were sent. 7.
Sometime a few weeks ago. Yeah. I mean.
Because he had a bad drug test somewhere along the line.
Right. That's you revoked his bond. He made a new bond. And then so he's now back on.
Okay.
Yeah. So he's.
Well, you have a drug patch?
Yeah, yes.
Well, what are we going to do?
At
It's
this
time.
point, let's set it for the trial docket.
Then that's what we want to do. That's what we want to do because we just go. If that's what you want to do. We're going to focus on this one and it'll be set and no deals. That's it. We go forward. That's 25 to life. And noted, this is a chance to resolve it. And there are no deals. We go to trial. Thank you. All right. Denise Woods, are you here?
Yes, we are.
What are you going to do? Is this it's a motion to revoke probation? Yes, that's what this is.
Yes.
Y'all ready?
State Street, Judge.
Okay. Where did Mr. Rennick say he was? 30 seconds out?
No, that was John. I haven't gotten in touch with him.
That was it. Aaron Simpson was to be pleaded out, I think,
Yes.
but we can't do it without an attorney. And Cameron Hernandez, is that what y'all were working on?
Which one was? Back. This one. This is what count.
Yeah. You know, y'all, hey, John, you know, these can be worked on before
We
15 minutes after the docket of the hearing.
week on this.
Okay.
Yeah, no,
All right.
there's a witness that's, there's a. Oh, no, it was just something he had a.
What are we
witness
gonna do
to.
on Cameron Hernandez?
That's a hearing. All these are hearings.
Okay, what are we gonna do on Terry Jackson? All right.
All three of these are hearings. That's what happened today.
Gary Jackson, I'm not ready to proceed on a hearing on it. It's like 5 new cases, and since I was in trial the last couple of weeks, I haven't had a chance to get all 5 of those.
What do you want to do?
We just have a quick reset for a couple of weeks, but from my understanding, I don't know if Mr. West even talked to him since he's been back from the hospital, because he was just found incompetent back in April. And
Yeah, that's his problem, not
Yeah, it's.
anybody else's. Sir.
Company's been in and out on him. He's been competent, incompetent, back and forth.
Okay. So what is he today?
Today, the state's asking for a continuous.
What's his, no, I'm talking about the competency. Have you talked to him? Is he lucid?
Go talk to him.
Is he lucid?
20th, and he wouldn't come out and talk to him, so I don't know what
We
he's
talked to
saying.
him right now, see if I'm going to, but he was, last time I talked to him, he was competent to me.
Yeah. Are you ready for a hearing on this today?
I could be, but I don't think the state is, but I can be.
So what do we do?
I think the state asked for some time.
Okay. How much time are y'all
He
talking
said
about?
2 weeks.
Is that good for you?
I need 3 weeks. I'm going to be on vacation in 2 weeks. It's my.
All right. I'm
Okay, for 3
gonna
weeks.
set Jackson for 3 weeks, but find out
I'll talk to him before I.
what his decision is today on his competency,
Yeah.
what he decides.
Yeah, let him decide that.
Well, of course, we're always going to go with the psychiatrist. The defendants seldom come in with doctors of psychiatry degrees.
That was Terry Jackson.
No,
3 weeks.
that was,
Yeah, Terry Jackson.
yeah, that's, Jackson's got 5 cases. Yeah. Would you say on Lacazzi or Lacase? Area of Lacase? It was an announcement, assault on a public servant.
She in custody? I don't know that one now.
She is in custody.
Okay. You want to do the hearings first, or are we talking to her?
You hadn't talked to her yet? Yeah, let's do the hearing. Let's do the hearing then.
Yeah, let me do the hearings on it. Like I'm ready on the 2 hearings.
Okay, okay.
At Mr. Jackson's house, Judge.
Which one first? You want to do, John?
It's up to the state, but I think Mr. Coleman's ready. He's fighting to be ready.
State Street.
On which case?
Woods.
Denise,
That's the, yeah.
I've got 3 cases, all right?
Yes, sure. 1 revocation and 2,
Okay.
It's interesting. Just gonna. Everyone's like on.
You're Denise Woods?
Yes, sir.
Have a seat right over there. We're going to have a hearing on all of this. 24 CR 464 is now called. The state of Texas versus Denise Ann Woods. That's you, Denise Ann Woods? You're here with Mr. West, your attorney, and the state's attorney. There is a motion to revoke unadjudicated probation in 24 CR 464. You are on probation for 10 years deferred or unadjudicated probation as of November 4th, 2024 for illegal possession of methamphetamine, second degree felony. And you are looking at up to 20 years in prison. We've got a new state jail felony in 25 CR 1101 filed a year ago. I just don't know why that is lingering, but it's a year old and it's illegal possession of methamphetamine that you're on probation for. And 25 CR 1841 is not surprisingly the third degree felony of illegal possession of methamphetamine, your drug of choice. And that is that one was committed on February 27th, 2025, 2 months after you were placed on probation here. In this case. All right. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Stand by for just a second. What are you going to do on yours?
It's a plea this morning, Judge.
Are you ready on it?
No, just got to finish the
Okay,
paperwork.
well, let me know when you're ready and then we can slip it in, okay? Because John's going to take a bit here. This,
Now, you want a question from the podium or from the council?
she'll be up here in a second. Whoever's called, the witnesses, we'll do it just like a.
Put his camera on.
Does the defendant waive a formal reading of the motion to revoke probation? I don't have any, I don't have a prompt on it. Can we proceed in summary?
Yes, Your Honor, please.
In summary, this motion to revoke probation alleges that on November 4th, 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for the second degree felony of illegal possession of a controlled substance, namely methamphetamine. Is all of that true and correct?
Yes.
Okay. Allegation 1 states you failed to report to the Jefferson County Probation Office on or about June, July, August, and September of 2025. You were what we call an absconder. And that's in violation of condition 4 of your deferred adjudication order. Is that true or untrue?
No.
I'm sorry?
Yes, sir. That's true.
2, you provided a urine sample on or about June 2nd, 2025, which showed the presence of marijuana in your system. And that is a violation of condition 10 of your probation order, which is don't use or possess any drug. Is that true or untrue?
True.
3, you state you provided a urine sample on or about June 10th, 2025 and June 17th, 2025, which showed the presence of methamphetamine in your system, a violation of condition 10 of your probation order. Do not use or possess any drug. Is that true or untrue? Is that true or untrue?
True.
All right. The 4 states you failed to provide verification of performing community service hours as required. Is that true or untrue?
True.
5, you failed to comply with the rules and regulations.
Very sorry to interrupt the court. I believe you're reading from a old MTRP. I am looking at an amended MTRP, which is the one that I was working on. It's undated, however. And the numbering is up, it's different from the numbering for the allegations you're reading off. My notes shows that this amended MTRP was filed July the 17th, 2026.
Well, it's not in this file. You can imagine how embarrassing that is for me. Don't we have people on, don't we have people who are helping on the filing here from the college?
Look,
Okay, I have, this is the last one I have is 10/1/25.
putting it out.
Okay.
Yeah, I thought these files were worked up.
Thank you. Okay. It's not the way we normally work. What I have now is an amended motion to revoke unadjudicated probation, which was filed on July 17th of 2026, which was just 10 days ago. Does the defendant waive any rights to additional time to prepare for this? Are y'all ready to?
Yes, we're.
Okay, y'all ready to proceed? Yes, ma'am?
Yes.
All right. In this amended motion to revoke unadjudicated probation, in this cause number 24 CR 464, once again, we're going to start from scratch. Please raise your right hand. Do you solemnly swear or affirm that the statements and testimony you're going to make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And in summary, this states that on November 4th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation for the second degree felony of illegal possession of a controlled substance, namely methamphetamine. That's true. Correct. That's all true and correct.
Yes.
Allegation one states you committed the felony of illegal possession of a controlled substance on or about February 27th, 2025 in Jefferson County, Texas, in violation of condition one of your probation order. And that order states commit no offense against the laws of this state or any other state or of the United States. Stand by. That is represented in the indictment handed up on December 3rd of 2025 in 25 CR 1841, where the defendant was indicted for the third degree felony of illegal possession of methamphetamine. Is that allegation true and correct?
Yes.
Two, states you failed to report to the Jefferson County Probation Office for the months of June, July, and August, as well as September of 2025 in violation of your probation order, which states report monthly. Is that true?
Yes.
Three, states you provided a urine sample on or about June 2nd, 2025, which showed the scientific analysis of marijuana in your system in violation of condition 10 of your probation order, which is do not use or possess any drug. Is that true?
Yes.
Four, you provided a urine sample on or about June 10th, 2025, and June 17th, 2025, according to this allegation, which showed the presence of methamphetamines in your system. Is that true or untrue?
Yeah, sure. It's true.
And then finally, you failed to comply with the rules and regulations of the Jefferson County Drug Intervention Program, JCDI, which was part of your probation order. You were required to attend and complete the JCDI program. Stand by. Where's this, according to probation, where's this, who's the probation officer on this one, please? Is that found in a probation order? It says in violation of special amendment filed on April 4th. Okay. Let's see. And that's April 4th of 2025. I'm looking at an administrative hearing dated April 3rd of 2025. And the recommendation was to the recommendation from probation to this court was to approve the order of the defendant continuing supervision, not being revoked at that time, but entering and successfully completing the JCDI program. And this states that on or about April 4th of 2025, that was entered into. I've dated it April 24th, though. I think the administrative hearing request is, the hearing date was April 3rd. I think it was submitted to me and signed on April 24th.
Your Honor, may I approach?
Hold on.
I have a copy.
Did you fail to comply with the drug intervention programs, JCDI, as ordered by the court?
Yes.
Are you pleading true then the allegations 1, 2, 3, 4, and 5 of this amended motion to revoke unadjudicated probation voluntarily, and because those allegations are true and correct as they are alleged?
Yes, sir.
Do you understand that a true and correct admission to one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced to no less than 2 nor more than 20 years confinement in prison, since this is a second-degree felony.
Yes.
Knowing all of that, do you insist on pleading true today?
Yes.
I find you are pleading true to allegations 1, 2, 3, 4, and 5 voluntarily, knowingly, intelligently, and because those are true. Okay, she's pleaded true to these. What do we do?
Your Honor, I'm sorry to interrupt, but had I known that she was going to plead true, Judge, I would not have brought the officer that arrested her,
Yeah, and they've got so many fires that they're fighting, and I wish that would have been done earlier today. I don't know what I can do about that, but it is a waste of the taxpayers' money, funds, and their time. They need to be out on the street. It would be nice to know if we're going to be disposing of these things without a hearing, they don't need to be spending their valuable time here sitting, watching the county that's the 21st largest county with the 15th highest crime rate in the state. All hands on deck, fighting the fire. I understand. You're frustrated. I am too, and they should be. but we're doing our job. And a defendant doesn't have to work on your timetable.
Understood?
They can consider options and then make their mind up at a subsequent time. What are we going to do?
I guess we just are, like,
It's unagreed?
It's unagreed. It's unagreed.
Okay.
Yeah, so we just.
So do you understand? Ms. Woods, there's no agreement here. So you're looking at the full range of punishment of no less than 2 nor more than 20 years confinement in prison. And you could be assessed a fine of $10,000. I'm not considering any of that. I'm not considering the fine. We're talking about confinement here, or any other option that the law allows. I consider it all, but generally violations of serious probation result in confinement. But what we're going to do is listen to both sides, and then I'll make my decision. Do you understand?
Yes, sir.
And you get to live with it one way or the other. But my oath is to be fair, and I strive to do that. Okay. Does the probate,
Have an opinion.
As far as a recommendation?
Yeah.
Well, I would like for her to be able to go to safety, but she has a pending charge, so that's out of the question.
And when you say pending charge, we're talking about out of another.
Yes, sir.
About what to do with this defendant, but at least your opinion today is safety.
It is, but she's not eligible, actually. So.
And you understand also,
okay, why isn't she eligible?
Which is the actual pending charge here that she received in February of 25.
Okay, I guess it's going to be she's got two pending, a state jail felony and a third-degree felony of illegal possession of controlled substances pending. And they're both alleging methamphetamine.
You understand, you got your opinion about what this case, how this case should be resolved. You understand the state's gonna give its opinion to the court as well, right? And our opinion may differ, in all likelihood, will differ from your opinion. You understand that? But at the end of the day, this court will be the final arbiter of what should be done. All right, I'll pass the question.
Morning. Your position is that she should continue on probation and get safety if it's possible, correct?
If possible.
Okay. And we understand that we have some technical hurdles we have to jump through because there's two pending cases in this court, correct?
Correct.
Okay. But if she was awarded probation in those two cases, with safety as a condition of those two new cases, that would be good.
Yeah.
Okay. And why is it that your opinion? Why do you want her to go to safety and get treatment versus going to prison?
Because I think she has potential. She's not pregnant. And I think safety is a great program for somebody with a drug issue and an addiction, instead of just sending her straight to prison.
And when you said you're pregnant?
She's pregnant, yes.
Yes,
So,
I've been clean for 8 months.
Ma'am,
I've been clean for 8 months. I have all my,
I'm supposed to be clean for life,
just letting you know, and I've changed my life around and I was
for the better or worse.
for the better, sir.
Go ahead.
So you believe this is a probation or defendant, whatever you want to call her, that can be helped?
Yeah.
Okay. Sometimes we get those that are just beyond help, right?
Correct.
We all see a lot of those. But this one, you believe she has potential to be successful.
I do.
Okay. And her violations are around drugs, right?
Correct.
Okay. She has an addiction. Okay.
Yes.
And that's why you're recommending safety to get her treatment, get her help to fix that problem. Okay. Because even her new offense is both drug related, aren't they? Okay. Has she committed any other crimes besides drug related crimes? Has she, I know she's behind on payments, but was she making payments and doing?
She's only made one payment since being placed on probation.
Okay. Has she been to meetings with you and met with you?
Yes.
Okay. Okay. So I know we have some missing meetings, but
Yes.
she has made meetings with you, right? Okay. And that's how you were able to form your opinion on her is speaking with her and getting to know her, correct? Okay. And you're asking the court to continue her on probation and try to get her some treatment.
Yeah.
That's what it's.
Nothing further from the state.
Thank you, ma'am.
State has no other witnesses, Judge.
Sir,
State has no other witness.
what's the defense say?
That's what called Denise Woods.
Come on up. Have a seat. I think I've already sworn you in, so you're still under oath. Thank you. Anytime you're ready.
Please state your name for the record.
Denise Woods.
And Ms. Woods, you are, you pledged earlier true to these allegations. You are currently on probation, correct?
Yes, sir.
Also, something else was just mentioned a moment ago, just get on the record. You are currently pregnant.
Yes, sir.
Okay, 7 months along.
Yes.
Okay. And you also made an allegation to the court a moment ago that you've been sober for 8 months, correct?
Yes, sir.
Okay, so before you were pregnant, you got clean.
I do.
Okay, all right. So we don't have any issues with that.
No, sir.
Sir,
We don't have any issues with that. Yeah.
what do you mean?
Being intoxicated or using drugs while being pregnant.
I have all my medical records from my doctor that you can pull if you need to be, that I have.
Objection, now responsive. There's no question in front of our judge. She just making the evidence.
Your objection's good, but I'm gonna let her
Yes, sir.
have an opportunity to be heard.
Yes, sir.
Let me just say, it's a scientific fact. You can't be a long-term methamphetamine user, get pregnant, and try to say, well, I stopped using it before I became pregnant. Thus, there is no harm to the child. You can't say that. That's not, you gonna interrupt me?
No, sir.
Now, come on, you gotta follow the rules, and we learned the interruption rule kind of when we were 5 years old. The scientific evidence shows that children born after people say they quit using methamphetamine still are harmed and have long-term problems. So you can't just say, I can stop and then all is well. Methamphetamine has serious consequences to you and a child that you're carrying in a womb. And it's not like the meth is gone overnight and has no lasting consequences to your well-being and things that form your DNA. Come on. Go ahead.
Thank you. That actually leads me into where I was going with that, is that you're an addict. Yes,
Yes.
she has to write that down. I'm sorry. That's your issue. That's your problem is you're addicted to drugs, correct?
Yes.
You said you've been clean for the last 8 months, but you know you're just a moment away from relapsing, correct? Okay. Apparently you can't get any drugs because you're in jail, right?
For now, yeah.
That's what I'm saying. When you're in jail, you can't be using drugs.
Right.
You heard the probation officer a moment ago suggest safety. You understand what safety is?
I do.
Okay. It's a program where you go away and it's like prison, you're locked up, but you get rehab and treatment and some skills.
Yes.
Okay. Would you be willing to do that if the court ordered that for you? So you can continue on probation?
Yes. I just, I have some questions about it.
About the program?
Yeah.
Okay. Well, if the judge orders that, you can answer that later, but it's up to the judge. But what your officer's saying is that she wants to get you treatment and keep you on probation and keep you going. Is that okay? And that's something you would like to do, correct? You want to keep going on probation?
That would be 10 more years after I did the 9-month program.
No, I don't know the terms of that yet. It'll be up to the judge on terms. But you'd be willing to do that if that's what the court ordered, correct?
I want to be home with my child. So just whatever option is that soon, as sooner than that.
Well, the safety you wouldn't be home immediately. You'd have to go to the program and do that first. You understand that, correct? Okay. But then you would be released back on probation.
Mhm.
So yes.
Yes.
Okay. Let me ask you this. What are you asking the court to do today?
I was asking for reinstatement.
Like this didn't happen.
No, just.
That's exactly what you're saying. Just reinstate. You're going to interrupt me all the time, aren't you? When I speak, the rules are you have to stop, but you get a fair opportunity to speak. You're on probation. You got 2 new charges since on probation. You got a motion to revoke probation with how many allegations of wrongdoing? Too many to count. You want to just pick it up where you left off? There's no consequences to your mistakes, your intentional acts of wrongdoing, which are the same acts that you were placed on probation for, and we held you accountable for in the first place. Thou shalt not commit crimes. These are felony offenses on methamphetamine, and you just can't stop committing felonies. But are you going to change your life, or do you just want it on your terms?
No, sir, I was changing my life.
The very first condition is don't commit a crime. Every time you touch methamphetamine, it's a crime. There's countless crimes here, countless. You're just going to pick it up where you left off, huh? You're going to have, well, there's consequences to your actions.
100%.
But you're also looking at 20 years on 2 of the cases, state jail felony on another. So you're looking at 42 years in prison, all of this combined, 42 years in prison. But you'd rather just pick it up where you left off.
No, sir, I'm not saying that.
Well, you're going to be held accountable like everybody else who knowingly commits violations after you've been warned. You made a promise to this court under oath. I will follow these terms and conditions of probation. How long did that promise last? Not long.
Darn, just for the record, the 2 new offenses, one of them happened before she was placed on probation.
Say it again.
One of the 2 new offenses we have happened before she was placed on probation.
Yeah, but she's using scent.
I know,
She's
but
been
I'm saying
testing
that
positive. Every positive test is a felony crime.
I'm just correcting the record that it wasn't 2 cases.
Well, the state can go and file those anytime they want, I guess, if they want to make a point of it. But it's not
I
necessary.
understand. No, I know, and she's put true to that. I'm just saying that one of those offenses was not part of this revocation. It happened before she was placed on probation. But
what's the most important thing to you?
of my family.
Or why are you using meth every day? Do you think that interferes with that family at first thing?
Yes, sir, I do think that.
Do you see that, or are you just
No,
saying it?
I do see that, but I've been clean for almost a year, sir, and I'm trying to turn my life around.
You ever heard, we all have free choice.
Yes, sir, I do.
You elect almost daily to make the wrong choice, knowing what the consequences are and looking into the eyes of your family. And you still go for you first. It's a selfish act. You're not supposed to be first. Third. That's what was told to me is our creator is first. Others, most importantly, family are second. We come in third. It's the difference between selfish and selfless. We're supposed to be selfless. That's, I think, the proper way under the law to act, especially when you're supposed to be a role model, a family head, a co-head of the family, setting good examples. It's not just, do you understand? You're just not living here alone on this planet. You have dependents who rely on you, and you're sitting there in jail. What do they learn from that? Okay. Fix this.
And Ms. Woods, fixing this is getting clean and learning to live the right way, correct? And you understand and you know that safety is a way to do that.
Yes,
And like I said, your probation officer wants you to do that. You're willing to do that. That would be the best thing for you, correct?
yes, sir.
Okay. Even though that might mean you might not get out right away. You might have to stay in and finish the program first, but then you have skills and living a better life, correct?
Yes, sir.
That's what it is.
Anything?
No questions, please, Judge.
All right.
Brief argument at the time.
Okay. You may be seated. Thank you. So, what should we do? Stay first?
Your Honor, you heard me make this argument before, so I won't belabor it. I mean, your order, and it is an order when you put it on probation, is not a suggestion and it's not an ask. It's an order, and she's chosen not to violate that order. And substance abuse, and I'm not making light of the illness that it is and can be, but there's also another component, Judge, and that's exercising, making good choices and wanting to make a difference or wanting to make a change. And she's demonstrated that she does not want to change. Not only has she been continuing to use, but she failed to do the JCDI program, and then she also failed to report as well, Judge. You can have drug issues and you can still report. You can have drug issues and still go and be in JCDI. And then lastly, I'll close with this, Judge. To give this defendant a second, third, fourth chance is not fair to those other defendants who the court has held or will hold accountable for messing up on the probation, and don't give them a second, third, fourth chance, Judge. There's time. The time has come for her to be held accountable, Judge. That's all I have.
All right.
Your Honor, my client's currently on deferred probation. There's another option that we have, the court has, and the court's done it many times before, is we can revoke her deferred probation, place her on regular probation, order her to go to safety as part of the condition, which is what her officer wants to have, to help her try to get everything straight. This is a punishment in the sense that now she'll have a conviction. She'll be a convicted felon. Okay. As of now, she's not a convicted felon, but after the court makes the decision, she will be. And then put her on probation, let her get treatment, let her get help, let her see if she's on the right way. And if she still continues this destructive behavior, then there's no more choices at that point. It's prison only. But right now you have that option to put her on a regular probation, and then handle these other cases as well. That ain't there, so she can go to safety, make a condition for all these cases. Not that you have to do it on all of them, but to put her on all of them just to be safe, and then get her some treatment, get her some help, and get her life turned around.
Your Honor, the probation department, I'm sorry, the probation department has informed me that safety would not be an option for this defendant, given the fact that she's pregnant.
What about that?
Well, we'd have to wait before she goes to safety after she gives birth, but she's only 2 months away. So
What does that mean? Probation. from probation, how long is she ineligible to go to substance abuse felony punishment facility under her circumstances?
While she's pregnant, Your Honor, she can't go to the treatment facility until
Then after the child is born, then what happens?
I don't know the specific time frame. If you want me to, I can get that answer for you.
Okay.
But until that point, she can stay in jail. That's part of her punishment, is staying in jail until that happens. I mean, that's a big punishment right there, having a child in custody.
Well, you know how pleased I am to see a birth certificate with born in jail.
I understand, Your Honor.
All right. I've got this motion to revoke probation in this case and these other two cases pending. What about those?
Your Honor, I mean, she's already pled true to one of them. I mean, they're both going to be pled guilty and some kind of agreement either worked out with the state or unagreed to the judge. So, up to you.
Here's what I want to do is I would like to revoke and put her on regular probation and send her to the substance abuse felony punishment facility, like the probation office requests and urges. I trust them. They have the highest success rate that I know of in this country on probation. So they're doing a good job. I like their recommendations and they're proven. I can't tell y'all what to do on the other two, but those other two need to be disposed of. And in a way that works with the court's plan on her going into substance to save P. Until then, though, I'm afraid she's not trusted to be on the outside, on the free world. She can't be trusted. And who to blame when she tests positive the next time she's released. So we've got to keep her in custody. And then after child is born, and then get her into the program where she needs to be. That's proven a success. The other two cases all need to get disposed of as well. I can't tell y'all how to do that, but there are methods of running all of this together and holding it over her head as well, so that if she fails, there's no other option left but 20 years in prison on two cases. Well, regular probation, that's 10 over 10, but there may be a deferred on another one, and then a disposition on the state jail felony where it can be packaged somehow so that it moves forward with dispositions that account for her failure to be responsible and failure to follow the rules, and then also the opportunity for her to get assistance for a healthier lifestyle for her and her child. That's what my plan is. So, what I'm going to do is find that there is sufficient evidence supporting this motion to grant it by a preponderance of the evidence or greater allegations 1, 2, 3, 4, and 5 are proven true. your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you had pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea. And State's Exhibit 1 admitted at that hearing to find you guilty beyond a reasonable doubt. I now, because your probation, your deferred or unadjudicated probation is hereby revoked, I now find you guilty of this underlying second degree felony of illegal possession of a controlled substance, namely methamphetamine, and this cause number 24 CR 464. You are hereby found guilty beyond a reasonable doubt, sentenced to 10 years in prison. That is suspended. You were placed on regular probation for the balance of time that you have been on probation, which is from November 4th, 2024 to this date. So that's about 15 months credit toward the 10 years probation. And it'll be the probation for the balance of time from which she's been placed on probation. That would equal 10 years. 10 years minus the difference between today and November 4th of 2024. Today being July 24th, 26. Does everybody follow what I'm my logic? Now we've got two other cases. What do y'all intend to do with those? If this state want to make a statement now or wait and work with him?
The state will make a one-time today only offer for a straight probation on both of those other outstanding cases that run concurrent. And that's for today only, so we can move these cases and get off the job.
So that would be 10 over 10 and 2 over 5.
Yes.
Yes, sir. With
For the
currently with everything.
felony and the state jail felon. Or what do y'all intend to do?
I will get the paperwork.
All right, do it, and then we'll sign it and move on.
Yeah. Thank you.
In the meantime, what do we do with the lady here on what do we do on the transfer to Safe P? I don't want her in the free world until she's ready to go to Safe P. What do I do?
We could, Your Honor, one of the options would be on these two new cases is have her plead today and hold off on sentencing trial after she has the baby. And then
No, how am I keeping her in jail?
because these new cases, the pending cases are still open. If you let her plead today but not sentence her, the cases are still pending, still open, and so she's still being held for that. I mean,
Also order upfront time, Judge. You can order upfront time on the 2
that's true too.
Yeah, that would be my preference, Judge, so that we
Yeah.
it's cleaner.
I do.
We dispose of these cases.
And how many months along are you, ma'am, on this pregnancy?
7 months.
7, so we're looking at about 60 days.
60 days.
All right, let's try it that way. Thank you. All right. That's what we'll do on Miss Woods. Y'all let me know when y'all are ready on.
Yeah, I'm gonna ask.
Well, you take your Mr. Ring, I'm gonna talk to Mr. Hernandez.
I'm sorry,
I think you have Mr. Hernandez to go. I'm gonna talk to
Scott, you ready?
I am.
Let's go. Thank you. What's the name? What's the defendant's name?
Give us instructions to John Winston, all these cases, they said he's probably fine, you know.
Sorry, it's Harry Sutton.
My friend.
About that. Take it serious.
You want to call you Ted?
I know. He'll call some place to live. It's like when you say without due respect. Makes everything you say after that, okay?
Come forward, does he need to see you?
No, sir.
No.
I already have.
You are Aaron Julius Simpson
Yes, sir.
in cause number 23 CR 267. You were here with Mr. Rennick, your attorney. The state's attorney is here. There is a motion to revoke probation filed May 7th, 2026. Thus, the defendant waive a formal reading of this. Can we proceed in summary?
Yes, Your Honor.
Raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion to revoke probation states that on September 11th, 2024, in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years in prison, and that was suspended. You were placed on regular probation for 10 years for the third-degree felony of evading arrest or detention with a motor vehicle. Is all of that true and correct?
Yes, sir.
One states you committed the offense of operating a motor vehicle while intoxicated with the open alcohol container on or about April 15th, 2026 in Jefferson County, Texas, in violation of condition 1 of your probation order, condition 1 being commit no offense against the laws of this state or any other state. Is this allegation true and correct?
Yes, sir.
Is that good enough for us to go on?
I'd like at least maybe 2 or 3, and then I'll be into the other judge. Allegation 2 and allegation 3 would be fine, and I'll be adding the remaining 4 through.
2 states you were at a location other than your residence at 1:41 a.m. on or about April 15th, 2026, which is a violation of your curfew in your probation order. This states that, let's see, you must be, let's see, where is it? And it's you. 17.
No, it's fine. Yeah, that's it. That can be solved. I haven't followed me.
Nothing is going to be easy because the curfew is not in 17. This is misstated. This is your community service restitution. Be inside your home every day between 10 p.m. and 6 a.m. is condition 18 of your probation order. I'll fix that.
Thank you, Judge.
Yeah, let's vote.
Is that true and correct?
Yes, sir.
4 states you failed to report to the Jefferson County Probation Office as directed on April 9th, 2026, violating your probation order, which states regular reporting. Is that true?
You haven't.
Are you pleading true to allegations 1, 2, and 4 voluntarily and because those allegations are true as they are alleged?
Yes, sir.
Do you understand that true and correct plea to 1 or more violations of your probation, that's enough to grant a motion to revoke probation? Your probation can be revoked. You can be sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. And our agreement's been reached in your case where you would be pleading true as you've done. Your probation would be revoked. You would be sentenced to 2 years in the state jail, 2 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
Did you sign
Yes.
State's Exhibit 1 there? Understand it, discuss it with your attorney? Is everything true?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, the states, if I follow this agreement, you are giving up all rights of appeal. I'm going to do this. Anything else to add?
No, Your Honor.
I'm going to find then, if nothing further, that there is sufficient evidence supporting allegations 1, 2, and 4 of this motion to revoke probation in this cause number 23 CR 267. As the defendant has pleaded true to those allegations voluntarily, knowingly, intelligently. That is enough to grant this motion to revoke probation. It is so granted by a preponderance of the evidence or greater. Your probation is hereby revoked. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years, and you will be given credit for all time you have served in accordance with this case. Do you understand what is happening?
Yes, sir.
That is all.
Thank you, Judge.
Thank you, John. Yes, sir. What else? What are we doing on Hernandez?
Your Honor, I believe we should be able to work out an agreement on that one. We're in the process of doing that. And LaCause is also a plea. I'm working on the plea paper on that one too. So
Okay, so Jackson and Lacoste, and what does that leave us?
nothing. Well, whatever Marcus's case is, but that's all mine.
Mr. Wilkerson's case.
Where's Mr. Wilkerson?
He texted me this morning about 8:15, said he was gonna be about an hour late, but I haven't heard from him. So
And I've got, let's see, Cameron Hernandez. I've got
I think they're
Ariel Paz,
yeah, you're right.
Aaron Wiggins. What am I doing with Aaron Wiggins? So that's the one, that's Wilkerson. I don't have Denise Woods anymore.
Good. Have it.
I'm sorry, I gave it back in. Okay. So yours and Wilkerson, what's going to happen on Wiggins? Does anybody know? It is that all about,
I think it's probably gonna be,
looks like an indictment, a murder.
looks like it's gonna be set for trial with mob running. Unless they want to take it, we'll see.
Well, it's a year old, sitting around. Let's see it. Reset for announcement in 413, then that was set for another announcement for today. All right, well. Was there any offer?
It was a 40-year offer made and I'm not budging on that, so
Okay,
I pretty much do that. If they don't take it today, we'll just put a trial and not make any more offers.
okay. So John, you're working on stuff.
Work on the plea, that's right.
If you can get that done.
We'll do. Got one of them done, work on the other two right now.
Yes.
Of course, you're on that.
We'll get more.
Okay.
I just wanted to look.
Can you see it?
Maybe. Yep.
The rest of them.
All of these are state bill.
Yeah, it's good.
Off camera, should be.
Hey, pretty good speech for the probation office, huh?
Great speech.
Thank you.
Well, y'all are special people and y'all do great things. Yeah.
I'll put jail on
In fact, I'm going to,
MTRP. And
I think I can do this. I'm going to order Mr. Laird to give y'all a raise.
Yeah, we'll see on
And-
this one.
Like that one. I agree.
And hopefully other members of the district attorney's office will put their fair share
Yeah.
into the pot
Yes, yes.
because y'all certainly deserve it.
Thank you.
And then I'll deduct certain fees and taxes and license. I'm sure you'll
Okay.
end up owing me money when I'm done deducting.
No, those
Those are
those are the kinds of fact situations that you just, it's not the way I grew up in Groves, Texas. It just wasn't like that. You spit on the sidewalk. That was a serious crime.
in Singapore, is it?
But, I mean, life seemed so simpler at that back then, and the rules were the rules, and we got along fine. Everybody seemed to do okay, and now it's just 1/3 of our caseload, drug cases. 1/3 are crimes committed because of drugs. 2/3 of all crime are now drug related. People wonder, well, what do we do about it? Well, there's the problem just right there in front of us. We got to deal with it and fix it. You know what the problem is free will. Humans are put on the planet, and it seems like we have free will, unless of the few who are unable to think properly. But that free will keeps us busy because people are consistent there's a consistent proportion of folks who are committed to making the wrong choice. John, you just checked that thing wrong just then. See, that's example A. John checked the wrong box just then. He intends to do that.
I may have.
What are you doing on your phone on that? What is that?
That's so I get the numbers.
Oh, you got a copy of the indictment or something?
Well, yeah, well, I saw it's running CC with these cases, so I know what numbers to put down on the thing.
Those things come in handy.
Oh, yeah.
Of course, there's a sign that says don't bring a phone in here.
There's that.
But right now, Your Honor, it's operating as my computer.
Hey,
okay?
you've got amnesty on that one.
It's my computer currently.
Yeah, 10 over 10 on that one other rating and 8.49. But
Yes.
that's a very great. And 205.
Condition of all of them or just the one?
I think it makes sense to make a condition.
I'm gonna put all three.
And don't forget the 60 days.
Yes, sir.
Yeah.
So in this other case, I can't think of an option. The child's got to be born in custody, right?
How much we have to do.
Technically, they take them to.
What a great beginning.
Well, yeah, they do. They're gonna go to the hospital. Yeah.
Yeah, baby's gonna be born in the hospital. She will be in handcuffs.
Unfortunately.
But babies born addicted suffer the rest of their lives.
Okay, for some reason, I'll just keep thinking of. Okay, it's 10 over 10, no fine. I've already gone on probation.
It's not-
Okay, so.
When we talk about the gift that keeps on giving, that's not what we intend.
Okay, for people.
Well, I deal with it on the daily. My adopted daughter was born severely addicted to methamphetamine, and she suffers
Was her
every,
level, was her levels high?
Huh?
Were her levels high when she was born?
she was born addicted to 8 illegal drugs.
Any condition.
But methamphetamine was very high, and she suffers every day. And so
That's smart.
it's,
Okay, half of the CPS cases.
it's just one of those things.
I guess the DPS people were on which case?
They were on, Simpson,
Okay.
yes. That was, Scott Rennick's case.
Okay. When Scott, yeah, I know as he pleaded guilty, they took off. Right.
Straight, it's called straight. It's a crime, not this called execution. I mean, we turned it on. I'm to speaking.
Can I get a cheeseburger? Can I get a cheeseburger? Yeah, I'll go with that up real quick.
You would let us to it.
No, it's not.
Yeah, loaded. Throw some jalapenos on it while you're at it.
It's soft coffee.
There you go.
That 5-minute verdict got some news, huh?
Yeah.
How do you get a 5-minute verdict? Didn't somebody have to go maybe use restroom or
Maybe not.
maybe not? Do you just volunteer
Foreman?
a foreman? You're the foreman.
Yeah. It takes that long just to get the foreman. though.
Yeah.
Right.
I don't think that, I think. Part of in there, just to
It was, I
see how it happens
it was
in real life,
definitely,
and then apply that to your skills and your job.
I learned what's really important to the jury and what's not important to the jury.
I think it is a good experience because, I mean, the stuff's secretive in there. So even though they can talk about it later, I don't think they do much interviews on television of their experience. So it's kind of a secret. How you doing, John? I got a birthday coming up.
Multiple ones done.
Got all seen.
All right, let me get everybody signed up now. I got everybody.
Thank you. Great.
I shot it, so I.
All right.
Three of them, Jay.
Great. Good. Wonderful.
Yeah. decide the punishment.
Today?
We can do it real quick. It's not
All right.
long at all.
All right, let's get something going.
But I have the other two. I'm gonna sign up right now.
Okay, thank you. Thank you. We've got some
Okay.
pleas in the queue. Stand by. So John is signing up 3 sets of cases? Is that our plan? Good.
Well, two and one's undergrade then.
Yeah, yeah. We're going to dispose of 3 sets and that takes care of today, right? So what are we trying next week, guys?
People,
Raymond Peoples. Pro se, thinks he's smarter than everybody else, might beat me again, we'll see, I don't know.
All right, we now call 26 CR 642, the state of Texas versus Area Sine Lacaz. Okay, it's almost French, from old France. You were here with Mr. West, your attorney, and the state's attorney is Mr. Laird, but that's okay. We've got backups. And we're dealing with the third degree felony of assault on a public servant, I believe. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, ma'am, this indictment alleges that on March 11th, 2026 in Jefferson County, Texas, you committed a third degree felony of assault on a public servant. Looks like a Jefferson County corrections officer. Do you understand what you're charged with here? Yes.
Yes, sir.
This is a third degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you are looking at with a full range of punishment?
Yes, sir.
The agreement's been reached between the parties. You were going to plead guilty, found guilty, sentenced to 10 years in prison. That will be suspended. You will be placed on regular probation for 10 years. And there will be terms and conditions of probation, which are normal and customary for this type of offense. Is this your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, man? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you were guilty?
Because I'm guilty.
I'm showing you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney, or the contents all true, correct?
Yes, sir.
State's Exhibit 1 is tendered into without objection. Among other things, this state you are mentally competent to enter your guilty plea freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You were guilty of the crime charged in an lesser included offense. God bless you. You were giving up your rights to a jury trial and the right to the apparent confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true as states. The bottom so health you got. State's Exhibit 1. This is made a part of the record. Any objections? No. All right. Do you understand what is happening here today, man? I'm going to follow this agreement. I'm going to find if nothing further that you are mentally competent to enter this guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third degree felony of assault with a public servant. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement shall be suspended. You are placed on regular probation for 10 years. There will be terms and conditions of probation that the probation officer is completing. She will go over those with you. I will sign these. Make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked and you could be sentenced no less than 2 no more than 10 years confinement in prison. And there are 36 conditions of probation, and almost all of them are requirements I have to follow, and he has to follow. Like, commit no offense, avoid bad habits, don't associate with disreputable people, work faithfully, support defendants, don't use or possess drugs, dress appropriately and conduct yourself in a proper manner. Those are the kinds of things I have to do. So this isn't something that is going to be hard for you. Just do it. And it's helps you be a better person all the way around. Right? And people have to take it, be respectful. You know, that's the right thing to do. And I think they'll do it. Just, but don't fail. Failure is not a good option, because if you do, you'll be back up here. You'll be looking at 10 years in prison. Who wants that? You got a life to live, right? Yeah. What do you do it for? What's your occupation? What do you do?
I don't have one. I'm gonna.
What are you training for?
Well, I'm
do my GED and then I'm gonna go to community college.
Good for you. Education opens doors of opportunity. Education, it has no limit to the value. It helps you make wise choices too when they're educated. Do well. You see the probation officer. Thank you. Next. Yes, John. Next. And Ms. Woods. Woods. Denise. I don't have Denise Woods.
You can impact him, Judge.
Okay.
If I can sign both those for me.
Denise Woods is who's up, and
We're doing up time on this. On these two new cases, we're gonna do it.
That's what, please raise your right hand.
yeah,
Should do it within 6 months.
Clear right.
We do it.
I mean, much larger than that. Again.
That's.
Right there. Right, that's like, no. Okay. Let's do it one more time. And right next to us.
Yeah, I just right down the street. I'll let them have a whole thing out since he's not. If it wants to work, I see it.
okay. Who's your lawyer? John?
John West.
John, yo. Hey, John, we've got Denise Woods here.
Yes.
I've also got Cameron Hernandez.
That's one we're gonna have to have a quick hearing with
And
you.
I've got Aaron Wiggins.
That's not mine.
That's Mr. Walters, and I'm gonna see if it's next to me.
Cameron Hernandez is yours. though.
That's mine. We're gonna have a quick hearing on that. Just,
Here,
he's
I'm gonna
pleading
give
true.
you
He
back,
wants you to sign the punishment.
Marcus, because I'm not
Mark
sure.
said he's not doing Judge, so
That's gonna have to be reset.
I'll go.
A week.
We'll set it for another couple weeks and see if we can get.
Oh, yeah. What are we gonna do here on?
This is the one we just had the hearing on, Your Honor, and we're doing that.
Concurrent probations.
Yeah. You revoked and put on regular probation as for the revocation of the two new cases. We're going to be doing a probation currently with it.
Well, I don't know, there's a lot of bleeding.
All right, back on 24 CR 464, again, the state of Texas versus Denise Woods, who's present with Mr. West. And there are two other cases here on this 24 CR 464. There was an amended motion to revoke unadjudicated probation. The court, after hearing, found true allegations 1, 2, 3, 4, and 5 of the amended motion to revoke probation, and the defendants deferred or unadjudicated probation was deemed to be appropriately revoked, and your unadjudicated probation is no longer there. I then found you guilty of the underlying offense, the second-degree felony of illegal possession of a controlled substance, and then sentenced you to 10 years in prison and placed you on probation for that. That is the foundation of what's going to happen on these other two cases, 25 CR 1101 and 1841. Does the defendant, Denise Ann Woods, waive formal readings of these two indictments and arraignments? Can we proceed in summary?
Yes, Your Honor.
25 CR 1101. In summary, this alleges that on or about October 4th, 2024 in Jefferson County, Texas, you committed the state jail felony of illegal possession of a controlled substance. And this carries with it, if convicted, no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable in this case, ma'am?
Yes, sure.
An agreement has been reached where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on a regular probation for 5 years. and this would run concurrently with two other cases. Is that your understanding of the agreement?
Yes, sir.
And what is this, 60 days upfront time
That's right.
as a condition?
Because to hold her in jail.
That's the older Jeff when she has the baby.
Oh, okay. God bless you. And as a condition of probation, you must serve 60 days in jail. And the idea is though that so that when it's time for the birth of the child, which is 2 months, that it's going to be in an environment where you're going to be free from access to drugs. And that's what we want. But any type of possession of drugs while we put you on probation can be catastrophic for you. You understand?
Yes.
Which means you would be separated from your child for a lengthy periods of time, probably. But this is your choice. Make the right choice. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this state jail felony? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1 here. Did you sign that?
Yes, sir.
Understand it, discuss it with your attorney, or the contents true and correct? Yes. State, we have to speak out, so she.
Yes, sir.
State's Exhibit 1 tendered into evidence without objection.
No objection.
Admitted. You're mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. You were guilty of this crime and any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, Your Honor.
State's Exhibit 1, Mark, made a part of the record for all purposes. Pre-sentence report waived.
Yes, please.
I'm going to follow this agenda if nothing further. I'm going to find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony. I am following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That will be suspended. You were placed on regular probation for 5 years. This will run concurrently with other cases. As a condition of probation, you must serve 60 days in the county jail, but it all depends on the birth of the child, of course. We want the environment of the birth of the child not to be in a facility, but in not in a jail facility, but we want an environment where you don't have access to drugs so that the child is not harmed. Plus, you must successfully complete substance abuse felony punishment. You'll be, and that's good. That most people, overwhelming people, are highly successful from that program.
You know, the other issue I have, I guess, if her baby comes before the 60 days, can we get the court to waive the rest of the time so she can get a safe P as soon as possible?
I want her in an environment that she doesn't have access to drugs.
No, I know, but I said, but if she has a baby before 60 days, can we waive that? And she still has to stay in jail to wait to go to safety. But that way she doesn't have to wait, like, say 2 weeks if she has it early, and then you get safety quicker.
Bring it to me when it happens and I'll work with you.
Absolutely. Okay.
Yeah. Do you understand what has happened today in this case, man?
Yes, Your Honor.
Good luck on that.
She's good too.
Finally, 25 CR 1841. And the defendant waives a formal reading. This indictment, we can go in a summary.
Yes, sir.
In summary, this indictment alleges that on or about February 27th, 2025, in Jefferson County, Texas, you committed a third-degree felony of illegal possession of a controlled substance, methamphetamine. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. And as a condition, 60 days in the county jail for the baby to be born in a safe environment. And as a condition, also you must complete substance abuse felony punishment facility.
Yes,
And you understand all of that to be the agreement.
yes.
If I follow this, you have no right of appeal. Do you understand?
Yeah.
How do you plead to this case? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes.
I'm showing you what's marked. You know what? I fouled up.
There was something that,
Yes.
the 1101.
1.841.
You still have it in the key.
I'm not, it's more open.
It was giving me problems earlier with.
Just give it a second, Judge.
On this one, I'm showing you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your committee. Is everything true and correct here?
Yes.
State's Exhibit 1 tendered.
Okay.
Without objection, it's submitted. The same thing as before. The states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You were guilty of the crime charged and any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
States Exhibit 1, part of the record for all purposes. Pre-sentence reports wait here.
Yes.
I will find and follow this agreement that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There is sufficient evidence supporting your guilty plea from States Exhibit 1 admitted to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of illegal possession of controlled substance. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That prison sentence of 10 years shall be suspended. You are placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow them, or your probation can be revoked and you can be found guilty and sentenced up to 10 years in prison. Do you understand what's happened?
Yes, sir.
All right. Thank you. This is 1841. I can't open it.
Okay.
It's locked.
Thanks, Judge.
Thank you. And I've got one more set.
So many things to sign. Okay.
Okay. What's next?
I'm gonna have her figure.
Cameron.
Explaining sure the allegations of the false court to decide the function.
I didn't write that.
And then, what are we doing on the other two?
Yes.
Yes.
I've got a second amended motion to revoke probation.
Yeah.
3933.
What happens on.
Oh, okay.
Sign those and then send it to me.
You know, these figures from the PC doesn't want you to some of the stuff. But I think it's a. You're right. Come on, right? No. Yes, I think.
I think we're just using the MGRP today and then.
Yeah, well, we might be trying all of them. I don't know. We'll see how this goes.
Okay, here, thank you. We now call 22-39335, the state of Texas versus Cameron Austin Hernandez. That's you.
Yes, sir.
With your attorney, Mr. West, and the state's attorney. There is a second amended motion to revoke probation filed June 2nd, 2026. Are you familiar with this
Yes.
in this case? All right. We're going to be handling the hearing on that. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
lower your hand. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, please.
In summary, the second amended motion to revoke probation states that on July 30th, 2024, in this criminal district court of Jefferson County, Texas, you were sentenced to 2 years in the state jail. That was suspended, and you were placed on 5 years probation for the state jail felony of credit or debit card abuse, or that offense, which is, standby, called, yeah, credit or debit card abuse. Is all of that true?
Yes, sir.
All right. What's he pleading to?
The new offenses.
Okay.
I mean,
Allegation 1, just states you committed the offense of theft of property on or about July 19th, 2025 in Jefferson County, Texas, which violates condition one of your probation order, which states commit no offense against the laws of this state or any other state. Do you understand what you're charged with here in this?
You said theft of property, yes, sir.
Yes, sir. Yeah, is that true or untrue? That allegation that you committed theft of property?
Where was the theft of property committed?
Got me. It says on or about July 19th, 2025. I have another one. Allegation 2 says theft of property on or about November 25th of 2025. Then there's a theft of property on or about October 15th, 2025, allegation 6. Then there's a theft of property, allegation 8, on or about October 21st, 25. Pick one.
There's a misdemeanor?
I don't know.
There's misdemeanors and felonies.
2 felonies and 2 misdemeanors.
Yeah, I don't know, but whether they're a misdemeanor or a felony, it's still a violation,
Yes, sir.
you know. So I can't tell you any more, but there's
Plead true to
1,
misdemeanors.
2, 3, 4, and then allegation 7 is you committed the offense of criminal mischief on or about November 25th, 2025 in Jefferson County, Texas. Are you familiar with that charge?
I'm not familiar with them, no, sir.
I'm gonna tell you, I don't know either.
Plead to the, yes.
You don't have a summary of?
Yeah, the shopping cart at one of the thefts.
Oh, which one is that? Let's see, you want to come back at another day or something?
Yes, sir, we need to, because he needs to know.
It's generic. These are generic allegations.
There's a lot of them.
And there's so many.
See, I talked to him earlier. I don't think he's
Yes, sir.
denying
I'm
any
not
of them. I
denying any of them, Judge.
think he's pleading
No.
to any of them,
Yes, sir.
or all of them. I mean,
Yes.
he's, that's not the issue, Ron.
Say it again. What do you want to do?
He's pleading true, to whichever offenses you want to pick, Your Honor. He's pleading true to all the offenses.
Yes, sir.
Is you don't have, does the state, can state help with just a short 1-sentence summary of what each allegation refers to?
Give me 1 second, Judge.
Mhm.
Okay, let's go back to the misdemeanors.
How much time does he have served on this 39335, please? They're all different dates.
Yes, sir. I'm getting each one. Starting with the misdemeanors and we'll get to the felonies.
Yeah, I don't know if it's a misdemeanor or, well, I can see.
Well, the
wait,
felonies
it's
occurred on October 23rd, 21st, 24th of 2025. Misdemeanors, let's see.
This misdemeanor shows on October 15th, 2025 at Game Exchange,
October 15th, you said?
2025.
Stand by, let
Game
me look and
Exchange.
see which one. Okay, that is allegation 6, that you committed the offense of theft of property, which is more than equal or more than $750, but less than $2,500 on or about October 15th, 2025 in Jefferson County, Texas, in violation of condition 1 of your probation order. Is that true?
Yes, sir.
Got
And there's a criminal mischief in there.
Yes, sir. That was a destruction of that was a damage to a shopping cart. I'm not real worried about it.
Okay, number 7 alleges that you committed the offense of criminal mischief of a value of equal or over $100, but less than $750. So that's going to be a misdemeanor. On or about November 25th, 2025 in Jefferson County, Texas, in violation of your condition 1 of your probation order. Is that true?
Yes, sir.
And I've got a theft on July 29th, 2025.
July 1?
I show that July, it actually happened on July 19th.
Okay, that's
2025.
allegation 1 of this second amended motion to revoke probation
There
order.
was a bunch of ribeye steaks, T-bone steaks, New York strips that,
Right. It alleges you committed the offense of theft of property of a value of equal to or more than $100, but less than $750. That's another misdemeanor. On or about July 19th, 2025 in Jefferson County, Texas, violating condition 1 of your probation order. Is that true?
Yes, sir.
Is that good, folks? That's 3. Are you pleading true to allegations 1, 6, and 7, these thefts of property voluntarily and because those allegations are true as they are alleged?
Yes, sir.
Do you understand that voluntarily and knowingly made plea of true to 1 or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can now be revoked. You can be sentenced to no less than 180 days up to 2 years in the state jail here in 39335. Knowing that, you insist on pleading true today.
Yes, sir.
I find you are pleading true to allegations 1, 6, and 7 of this second amended motion to revoke probation voluntarily, knowingly, intelligently, and you've had adequate time to speak and discuss all of this with your attorney, Mr. West.
Yes, sir.
All right. What should we do? Go ahead.
We would request somewhere along the lines of the lower end of the punishment range in this case, based on the facts of the case. This is not a case that wants to 2 years. My client's been in custody. He has, I'm not sure how much time he has.
124 days.
There you go. He has probably credit. So we'd be asking something along the lines of credit for time served from what he's already got. And I believe that's what you want, right?
Yes.
Yes, okay.
Okay, Dan.
Judge, I'm asking for the 2 years. He's committing crime after crime after crime after crime while he's on probation for a theft type crime. He just won't stop. And I don't know what he expects to get out of this when he just blatantly just goes out and commits crimes while he's on probation for a felony. So we'd ask for the 2 years.
But anything you'd like to say? Go ahead.
I just, made a mistake. I made a few mistakes, quite a few mistakes,
What are these based on? Why are you making all these mistakes?
the thefts of property. I was working once I got out of probation for a while, and then I lost my job, so I just started making bad decisions. Really, I don't have any excuse for it. You know, just the way I was making, I guess, income at that time, which wasn't the right way to do it. No.
Okay. Well, what we've got here are, Alex, you're pleading true to 3 separate crimes while on probation. So, it's kind of, and this is a 4th crime that you're on probation for, already found guilty. So you got to stop committing crimes and live honestly, follow the rules.
Yes, sir.
All right. Anything else? If nothing, I'm going to find that there is sufficient evidence supporting the second amended motion to revoke probation to granted by a preponderance of the evidence or greater, as allegations 1, 6, and 7 have been proven true beyond a reasonable doubt. The defendants committed theft on 3 separate occasions, as alleged in 1, 6, and 7 in this second amended motion to revoke probation. Thus, your probation is hereby revoked. You are hereby sentenced to confinement in the state jail for 2 years. I see 424 days. You've been given credit toward. So 365 days a year. So, 2 years is 730 days. Now, we've got a state jail felony of theft and a state jail felony of theft that you have separate crimes over. So what are we going to do with these?
Up one.
That was the plea.
That was the plea. That was before.
Well, what do we?
Now we got to talk about it, Judge. I mean, the offers 2 years on those 2, but I was running them concurrent as a plea and told him I might try to stack them if he started playing these games, and here we are.
Well,
so we might need to talk about. Well,
was the intent to plead guilty to these 2 new ones and then everything to run concurrently so he doesn't get stacked on? He could be looking at 730 days times 3, which is 2,200 days. That's a lot of time, but I thought there was some talk about maybe running them concurrently.
That was the plea offer to run it concurrently. But he said no to the plea offer. I would like him to run concurrently.
Okay, well,
that's
your choice, but
I was just trying to have a hearing to.
Well, here it is. You got the hearing, and that's a ruling of the court. These other ones.
Let me talk to Mr. Laird and see if we can. How we can resolve those.
All right. Is that something you want to do today, or is that you're going to need some time?
We need some time, so I think I need Mike to move on.
Can I reset 1 week?
I'm going to be out for the next 2 weeks. I have CLE this week and family vacation.
Well, he's not going to go anywhere for 2 weeks, but he needs to know where his life heads with all 3 of these. And
we can do it
it's obviously in its best interest to package them together if that can be done. That let me agreed upon.
Talk to Mr. Laird.
2 weeks,
3 weeks. Because I'll be out next Monday.
All right, I'm going to reset this for 3 weeks.
3 Mondays from now. It's not full 3 weeks, but it's.
Lacey, did you get it? Okay, let's reset, sir.
Yeah, that Monday after.
See what we can do. Thank you. Is that it? We've done.
That's all for me.
We're in recesses. What do we have?
Fresh like the morning, mouth wide open like they yawning. Every time they see me, they in G-Shock. Homie, this is too far. Homie, I feel too alive. You can see me like Illuminati. You can see me like Illuminati. But I'm shining so bright, so bright. Don't come and try to share some of this light, no. Give me a beat and I control it like a maestro. Ladies on a mission, they be trying to get me wiped up. shawty, wait a minute, can't tell if I like ya. Gotta make sure you know how to shake it like a bartender. Team with me and they all winners. And you know we ballin' all winter, all summer. Jewelry around my neck is lightning, but I'm all thunder. Keep coming with it. Keep coming with it. Keep coming with it. Place your bets on us. Get your money and flip it, yeah. Keep coming with it. Keep coming with it. Keep coming with it. Place your bets on us. Get your money and flip it. Bring a friend and come along. Don't be taking too long. The vibe's too strong. If you don't know how to move, then we moving on. Ain't no way rhythmic feet up in this place. If you can't catch the feeling, then get out the way. I've been reeling and fish from the lake. They keep saying I'm down to earth, but I'm really out of space. All these women aliens, super foreign, so exotic. Hop in the Mercedes Benz, and I got them crushing like ice pouring the bub. It's overflowing on us. You drop it, then pick it up. I think I'm falling in love, but shawty, this isn't what you probably thinking it was. It's a vibe out, cooling it for the weekend. It's us. You gon' find out once you come on and bring me that up. Keep coming with it. Keep coming with it. Keep coming with it. Place your bets on us. Get your money and flip it, yeah. Keep coming with it. Keep coming with it.